Welcome to Talk Law Radio with attorney Todd Marquardt of the Marquardt Law Firm at marquardtlawfirm.com.
I'm Todd Marquardt, and today we're talking about deeds on 9:30 a.m. The Answer. We're live on Facebook, and we'll be on YouTube later on this week. So I wanted to explain first, what is a deed for? Some people may not know. We use a deed to transfer title, sometimes from the seller to a buyer, sometimes from the gift giver to the gift receiver. And I was just telling you before the break that a deed has to be in writing, has to be signed, and has to be delivered. But an unrecorded deed is still binding on the party to the instrument. That means the grantor, his heirs, and assigns. But we have to talk about the bona fide purchaser for value. Now, bona fide is Latin. Lawyers like to use Latin still. That just means in truth, in fact. A conveyance of an interest in real property must be in writing, signed, delivered. I already told you that. So let's move on. What is a warranty deed? A general warranty deed conveys to a grantee a fee simple estate in real property with a covenant of general warranty, subject to the reservations and exceptions stated in the deed. We have to define several things there. I'll give you the simple layman's version of the definition. So when we say convey, that means transfer, to go from one person to the next. Fee simple is what we call the totality of the property rights that you're going to receive. There are different rights that you could grant and convey to the grantee, to the beneficiary. You could hold some of those rights back. And so in real estate, we talk about all of those rights like a bundle of sticks. So you could leave some rights out. You could include all of the rights. Fee simple means that you're going to own it, all of those rights together. And the covenant, that's like a promise or a provision in a contract. It includes the general warranty. Now, you probably are thinking in your mind what a warranty is, like a car warranty or a refrigerator warranty. Anything you buy nowadays at the store, they ask you, do you want a warranty with that? Because that way they can charge you extra. And if it's a good product, you'll never use the warranty. And so they just get free money for that. Well, it's kind of the same thing when we're talking about real estate. The customary warranty clause describes what the grantor binds. So it obligates the grantor to indemnify the grantee against any loss resulting from a title defect or from any encumbrance that arose before the conveyance. So a title defect might be that one of those sticks in the bundle isn't actually owned by the grantor. Or if there's an encumbrance, what that would be is like a lien from money that the grantor owes somebody, like a mortgagor, or like money owed to a contractor or a mechanic. So those liens can be filed and they're against the property. If the grantee is damaged because he doesn't get to fully exercise all of his rights on the property, then the grantor would be responsible under this warranty. Now, there's all kinds of exceptions. I'm just giving you the 30,000-foot view of deeds and warranty. The next thing I want to just mention briefly, because we got to talk about it at some point, is community property. You know what community property is, right? if you're listening to this message, chances are you're in Texas. Texas is one of a handful of states that has community property law. And what that means is that you share property with your spouse. Under the inception of title doctrine, the character of property, whether separate or community, is fixed at the time of acquisition. Separate property consists of the property owned or claimed by a spouse before marriage, or it could be property acquired by a spouse during marriage if it's received by gift, devise, or descent. By gift, whether it's an inheritance or a lifetime gift from somebody else. Or separate property is also the recovery of personal injury sustained by the spouse during marriage, except for lost earnings. A spouse may set aside all or part of their community property as separate property by partition or exchange agreement, like in a premarital agreement or a prenuptial agreement or a postmarital agreement. Community property, on the other hand, is property other than separate property. And there's a presumption that property acquired during marriage is community property. Now, you can rebut that presumption by proving one of those other things by clear and convincing evidence. Okay, so you got to hold that in the back of your mind when we're talking about deeds, because if you want to give your property, or if you even want to sell your property to somebody else, your spouse may have to sign, because even if your spouse is not named on the deed document, they still might have a 1/2 interest by presumption. Okay, let's talk about special warranty deeds. Now, the special warranty deed is something less than a general warranty deed. By converting the general warranty to a special warranty, the grantor warrants to defend the title conveyed to the grantee only to the extent that claims are made by, through, or under the grantor. Special warranty covers only title defects caused by the grantor, not those caused by the grantor's predecessors in title. So that's less than what would be covered by the general warranty deed. In the general warranty deed, the grantor does warrant those defects or encumbrances even before the grantor got the title. So title insurance coverage for covenants of warranty is available through an owner policy of title insurance. If you're interested in title insurance, I did a show a few weeks ago, so you can search on talklawradio.com for that episode about title insurance. I interviewed Matt Profit with Security Service Title Company. We talked a lot about title insurance. Okay, next, what would a deed be if it doesn't have a warranty? There's no requirement that you include a warranty in your deed. A covenant of warranty is not required. That's in the Texas Property Code section 5.022b. The deed without warranty passes the grantor's title to the grantee with an express exclusion of warranties. The deed relieves the grantor of any warranty responsibility for title defects, yet provides the grantee a true deed as opposed to a mere quitclaim. Now, don't get all excited like you're glad that you're not going to include any warranty for the buyer, because the buyer may not want your property if you're not going to give any warranties on it. It's very common for the buyer to acquire the property with all of these warranties. And so if you're going to include less than that, then maybe they pay less, or maybe they don't want the property at all. So I just told you that a deed without warranty conveys the property as a true deed as opposed to a mere quitclaim. So what does a quitclaim do then? Glad you asked. A quitclaim gives notice to the grantee that title to the property may not be clear. So you can't have a bona fide purchaser for value here. Thus, if the grantor has title to the property but will not warrant title, a deed without warranty is preferable. Sometimes people talk about using a quitclaim, but title companies really hate this. And they see a quitclaim as a red flag, like it might be fraud or forgery. And so you might have to explain why there's a quitclaim in the chain of title. So the title on property is not really like the title of a motor vehicle. When you get title to your car or truck, you have this piece of paper that has your name on it that says you're the owner. Well, in real estate, lawyers have to deduce who the owner of the property is by looking at the chain of title. Each deed that has been passed from seller to buyer to those who might inherit from them, all the way back to when Texas was founded, that's a chain. And so each conveyance is a link in the chain of title. And at the title company, when you're getting title insurance, they'll look at the chain and see if there are any defects. You know that you have title to the property if you're the last one in line. Okay, so we've been talking about deeds, general warranty deeds, special warranty deeds, and let's see. Let's do another quote. Andrew Carnegie said, 90% of all millionaires become so through owning real estate. John Rockefeller said, the major fortunes in America have been made in land. Interesting. Okay, so you know this is Talk Law Radio. I'm your host, Todd Marquardt. We're talking about your hidden legal issue blind spots, which might be using the wrong deed or buying property that has a defect in title. And so I just want to clear up any misconceptions that might happen between general warranty deeds, special warranty deeds, deeds without warranty, or quitclaim deeds. We also talked about community property. Okay, I want to go to what is a gift deed? Well, that's when you receive it as a gift. You didn't pay for it. And so that's a good thing, right? Well, it might be. There might be some hidden issue, legal blind spots in that area as well. So let's talk about how it's different from a deed that you pay money for. Well, the essential elements of a gift made during a grantor's lifetime are there has to be donative intent, delivery, and acceptance. So I read this court case about two guys that were fighting over some stock, and the guy that had it said, I never promised you anything, I never gave you anything, you're just a small fry in my book. The other guy said, no, you gave me the stock, you said that you would, and so I have it. And the court said to find the existence of the gift, there must be proof. You have to have evidence of donative intent, delivery, and acceptance. And so in this case, when it's stock, the receiver has to actually have it in his hand. Well, I have to take another break. Stay tuned. I'll be right back.
This has been Talk Law Radio with attorney Todd Marquardt, brought to you by the Marquardt Law Firm. You can learn more at marquardtlawfirm.com. And be sure to listen to the full Talk Law Radio show Saturday mornings at 11 on 9:30 a.m. The Answer.